Welcome to Bloomberg Law for this Friday, May 27th. I'm June Grosso with Michael Best. A jury has sided with Google in a nearly $9 billion copyright case brought by Oracle. It's the second trial, but no end in sight in the 6-year legal battle over Java software as Oracle plans to appeal. The case could have resulted in the largest copyright verdict in U.S. history, but it turned into a verdict for the defendant. After deliberating for 3 days, a San Francisco jury unanimously found that Google's use of Oracle's copyrighted software constituted fair use. Oracle sued for nearly $9 billion, alleging Google needed a license to use its Java programming language to create Android software used to run the world's most popular smartphone. For 6 years, the case has gone through twists and turns, including 2 trials, and it's not over. Oracle says it will appeal. Michael?
With us today to talk about this case are Tyler Ochoa, professor at Santa Clara University School of Law, and Professor Michael Reich of Villanova University School of Law. Tyler and Michael, thank you very much for being here. We're so happy to have you.
Happy to be here.
Yes, thanks for having me.
Michael, can you explain for us what exactly the jury decided in this case?
Sure. The jury had a very specific question it was asked. It was asked if the way that Google used the Oracle code, the header code, we can talk about what that is, but these lines of code that allow programmers to write using Java language was a fair use or not. And the jury form was deceptively simple. Was it a fair use or was it not a fair use? And they just checked one of the boxes and decided that it was, in fact, a fair use. Now, the fair use determination is very complex. There's 4 different factors. There's all sorts of things you can look at to make that determination, and we don't know what the jury relied on to get to that ruling. But in short, that's basically what the jury did.
Tyler, we spoke when the trial was just starting. Were you surprised at the verdict?
I was pleasantly surprised. I was hoping that the jury would get it right, and the jury did indeed get it right. But this case never should have gotten this far at all. It was the Federal Circuit that revived the case after the trial judge had sensibly ruled that the aspects of the Java programming language that Google allegedly had copied weren't protected by copyright. Copyright isn't supposed to protect functional things, and the things that Google copied were very functional. The Federal Circuit disagreed and said that they were protected by copyright, and then sent it back for a fair use trial. Fortunately, the jury decided that this was a fair use, and therefore reaching the same result through a different means of reasoning.
So, Michael, we've had a situation now where the appellate court said there's a copyright, and the jury has now said that that Google's use was a fair use of copyrighted material, I guess. So what does that mean? What exactly is fair use in this context?
Well, fair use says that even if something's copyrightable, you have the right to do what you did. And the problem with fair use, so I agree with Tyler on this, the problem with fair use is it's very fact-specific. So what it means is, in this case, this jury said that this use was okay. And because it's very fact-specific, it may be hard to overturn on appeal. But what it doesn't tell us is what's going to happen the next time somebody does something that is the same or even similar, because if you leave it up to the jury, the next jury could go the other way.
Tyler, were Google's witnesses just more convincing? You had the chairman of Alphabet who'd worked at developing and marketing Java at Sun Microsystems and seemed to know both ends. Did you find that their testimony was more compelling?
Well, I suppose we'd have to ask the jury which testimony was most compelling to them. But I think the key to understanding this case is Google did a whole lot of work. They didn't just copy all of the API methods and classes and packages that were in Java Standard Edition. What they copied instead was basically the names of those methods and the organization of those methods into classes and packages. They copied the declaring code, the first line of code in each program that says, here's the name of this method and this is what it does. But they wrote their own code to implement each of those methods. So what Google took was really just the names and organization, which was less than 3% of the code in the 37 API packages that were at issue, and even a smaller percentage of the total amount of code in Java Special Edition. The reason this was fair is why Google wanted to do this was because programmers had already learned to program in Java and were familiar with these names for accomplishing these functions.
After 3 days of deliberations, a jury has sided with Google in a nearly $9 billion copyright case brought by Oracle. It's the second trial, but no end in sight in the 6-year legal battle over Java software as Oracle plans to appeal. We've been speaking with Tyler Ochoa, professor at Santa Clara Law School, and Michael Reich, a professor at Villanova Law School. Tyler, you are one of 41 academics who agreed with Google that the code it issued did not merit copyright protection and urged the U.S. Supreme Court to review the Federal Appeals Court ruling in 2014, which the High Court declined to take. Since that ruling is still in effect, and since fair use is very fact-specific, how much relief is this decision, is this jury verdict to software developers and to the industry in general?
Well, it's certainly a big relief that Oracle didn't win at the trial court level. Had that happened, all sorts of people would have been very skittish about writing code that was compatible with some other program without getting a kind of license. Now, that still may be the case. The Federal Circuit's opinion may have a bit of a chilling effect just because most companies don't have the resources to fight a trial on fair use the way that Google did. But Google's victory will encourage companies that are inclined to push the envelope, to take risks, because it makes it somewhat more likely that they would prevail in a trial if they were sued for copyright infringement in the future.
Michael, have any companies that create this sort of software or API tried through licensing agreements to limit the ability of people to use it?
You mean Java or in general?
Java or in general?
I don't think so. I mean, this has been an unsettled issue for many, many years, and the fact that it took a long time for this issue to percolate before this case, and even since this case, it's not like we've heard of a bunch of other lawsuits that have sprouted up, leads me to believe that either folks are not worried about it and things are just happening, or there are licenses that we just don't hear about. So I think there may be licenses out there, but I suspect if there are, they come with some technical know-how that gives some benefit beyond just the ability to use the APIs. What Google did here was a remarkable amount of work, and I don't think you see the kind of full direct emulation of another API the way Google did very often. So this is not a question, I think, that arises that often.
Tyler, and if another case should arise, and let's say it's in the Second Circuit, will that federal district judge follow the Federal Circuit, or will that federal district judge be able to decide by himself or herself whether it's copyrightable or not?
Well, the only appeals that go to the U.S. Court of Appeals for the Federal Circuit are those that involve patent law in some portion of the case. That's the reason the appeal in this case went to the Federal Circuit rather than to the Ninth Circuit. So a district judge in the Ninth Circuit or in the Second Circuit would not be bound by the Federal Circuit's decision. He or she would have to independently decide whether or not they agreed with it. And certainly the Federal Circuit's decision conflicts with sort of what has been accepted wisdom for the past 20 years in software copyright cases, and in particular with a decision by the U.S. Court of Appeals for the First Circuit in the Lotus versus Borland case that was decided in 1996.
Michael, if Oracle appeals here, is there any possibility that, say, if the case goes up to the Supreme Court, we might actually get a reconsideration of this copyright issue? Or are we, it's because it's beginning to sound like we're not entirely stuck with it, but if everything keeps going back to the Federal Circuit, we're going to be in a position where this is the law of the land, when a lot of people in programming seem to feel that this is the wrong copyright decision.
I don't think so, because I don't think everybody agrees it was the wrong copyright decision. I know lots of people do, and Tyler and I disagree on this. We agree on the outcome of the case, most certainly, but we disagree on the best way to get there, and the most expedient way to get there. I think the court, if the court had serious concerns about ruling that this was copyrightable, it would have granted cert earlier, perhaps, so as to avoid having to deal with the fair use. I suppose it could come back up and have it be reviewed again, but I think it's unlikely, because for that to happen, Oracle would have to win on a reversal of the fair use at the Federal Circuit, and then Google would have to appeal again to the Supreme Court on this issue of copyrightability, and I think that's unlikely. I think that series of events is very unlikely, no matter how you feel about the Federal Circuit's opinion.
Tyler, Oracle said it saw many grounds to appeal. So there may be many grounds to appeal, but how difficult would it be to overturn the jury verdict?
I think it's going to be quite difficult to overturn. You can't just appeal a jury verdict because you disagree with what the jury did. It has to be something that the trial judge did wrong. Either the jury instructions were incorrect, which is the most common ground for an appeal, or because there was some significant error in the admission or exclusion of evidence. And I don't see that here. I think the evidence was very straightforward. I think the jury instructions were very solid. I don't think there's really much of a ground for an appeal here at all. I would be quite surprised if Oracle was successful in getting this overturned.
Michael, Google's won now, but there was some evidence during the trial in the form of emails that Google had some concerns, at least, about whether they were violating Oracle's copyright in doing the work that they were doing. How did they get around those emails?
I think it's a red herring, those emails. If you look at them, they're very early in the process. And in context, it seems that if they're going to use all of Java, then they need to license. I didn't read anything in those emails that said if we use just the APIs and write all of our own underlying code, then we need to license. I think they were really just talking about two different things, and I think the jury thought so too, or else it would have ruled differently.
Tyler, final thoughts on this case? Well, final for now.
Once again, I'm pleased that the jury came out the way it did. And even though Michael and I disagree on the basic copyrightability, I think we both agree that the jury reached the correct result in this particular case. And I think a lot of programmers are breathing a sigh of relief for now.
Thank you both for being on Bloomberg Law. That's Professor Tyler Ochoa of Santa Clara Law School, Professor Michael Reich of Villanova Law School. Now let's take a look at some of the top stories on BloombergLaw.com, Michael.
Verizon Communications and its two unions reached an agreement on a new labor contract this afternoon, paving the way for about 39,000 landline employees to return to work after a 44-day strike. The walkout by the Communications Workers of America and the International Brotherhood of Electrical Workers has been one of the largest in the U.S. in recent years. The labor standoff pushed the number of striking U.S. workers to the highest in more than 4 years, and according to the Labor Department, could depress the May jobs numbers slated for release next week.
A former Barclays trader on trial for rigging LIBOR was admonished by a judge today for a court outburst that interrupted a co-defendant while he was being questioned by a prosecutor. Ryan Wright shouted, "No, no, no, no," from his seat on Friday after the prosecutor asked fellow ex-Barclays trader Alex Babban if the LIBOR rate affected swaps valuations. After the interruption, Reich's lawyer told him to be quiet, and Judge Anthony Leonard said interruption should not take place. They are on trial for conspiring to fix the London interbank offer rate, or LIBOR, a benchmark tied to trillions of dollars in securities and loans. Another ex-trader, Peter Johnson, has pleaded guilty to the charge. Michael, that's something you see in the movies or on TV, not usually in a courtroom.
Well, courtrooms can be very exciting places, June, and sometimes in ways that you don't expect.
Exactly. That's it for this edition of Bloomberg Law. We'll be back on Tuesday. Thanks to our technical director, Reginald Bazile, and our producer, David Sucherman. With All Due Respect is next for our Washington, D.C. audience, and Bloomberg Best is next for our listeners in New York, Boston, and San Francisco, right here on Bloomberg Radio. I'm June Grosso with Michael Best, wishing you a wonderful Memorial Day weekend.